Ladies and gentlemen, gentlemen and ladies, ladies and gents, this video is being done in reference to the Defrauded Homeowners of America lawsuit. Need to let you go. Let you all know that we have to do what's called a notice of appeal. The reason why we have to do a notice of appeal is because the judge actually said that he was not going to hear the reconsideration. Now let's find out what the judge decided, because it's important that you guys hear it in his own words. Now, mind you, there's a lot of things that I would like to say, and I do my notice of appeals a little bit different than everybody else. See, the notice of appeal becomes record evidence in the case, so I introduce information in my notice of appeal. It's a sealed opinion, but we don't have to seal it anymore. Appearances, it says that I'm supposed to be pro se. Ladies and gentlemen, I'm not the plaintiff, I'm not pro se. But this is what he says. Pro se plaintiff, EON, has moved for reconsideration of this court. October 26, 2017 opinion. The October 26th opinion dismissing the plaintiff's action with prejudice based on the facts and conclusions. See, he's now telling us that he's given us facts and conclusions of law. You're going to see that he doesn't give us any facts and conclusions of law, but I'll explain it to you in a minute, and you'll see that I'm not just any booty filing a lawsuit. And that's what he thinks this is. He thinks that I'm just some idiot that he can trifle with. And I'm saying this way because he thinks I'm not a challenge to him. So let me explain to you how the appeals court will have no other choice but to remand this back to the court. And I'm definitely asking that we not get the same judge when it's remanded. Okay, the attorney general is pretending they never received the service of the documents when they did. Now, if there's a service issue, if we're saying they received it, they're saying they didn't receive it, the normal course for the court to do is to order for reservice to be done, and to be done through someone like the marshals. Okay, but they're not saying on record that they didn't receive the documents. The court is saying that we haven't provided proof. So we sent them an affidavit and a copy of an affidavit that was signed by a notary and a copy of the proof of service. The court ignored it as if it never received it. You'll see it in just a second. The plaintiff's motion for reconsideration is denied. Okay, ladies and gentlemen, when I respond back to him, because I'm representing the Defrauded Homeowners of America, and more than 10 million people, and the United States of America, I have to be respectful. So this is what he sent. The facts underlying this action were previously set forth in the October 26th opinion of this court. Remember, he doesn't say the opinion of the judge, he says the opinion of the court. Knowledge of which is assumed. It's assumed that y'all are supposed to know what we're talking about. See, Defrauded Homeowners of America, etc. all versus Federal Reserve et al. 17. It's a sealed case. You can't see it. Certain facts are repeated as relevant to the instant motion. Pro se plaintiff commenced this qui tam action on August 20th, 2017 on behalf of the Defrauded Homeowners of America, DOA. It's supposed to be D-O-H-A. DOA, but DHOA. Anyway, against the Federal Reserve Board, Federal Reserve, and those 1 through 20,000, those. Collectively, the defendants, alleging, inter alia, violations of the Federal Claims Act. Ladies and gentlemen, you guys saw the lawsuit. We weren't just going under the Federal Claims Act. We were going under several other provisions of law. And I was coming in as an individual and as a relator. But anyway, we'll talk about that in a minute. Again, it doesn't matter. They say what they want to say. So I'm not gonna be arguing whether or not I said this or said that. We're gonna be arguing the facts. You'll see in a second. The plaintiff filed the action under seal, but did not serve the complaint, or any other documents related to the action on the United States government, the government. Ladies and gentlemen, again, we have an individual who is willing to testify that he personally hand-delivered the documents to the Attorney General's office, and their cameras, because they have cameras, will document that he served the documents. However, he said that we didn't provide any other document related to the action, okay? Did not serve the complaint or any other documents in the action of the United States government. But we provided a proof of service to the court. Now, the stuff in red is what I added. On October 26th, this action was dismissed sua sponte on the court's own motion, both because, and he says both, because the plaintiff failed to properly serve the government as required under 31 U.S.C. 3730B2. Then he says one, so we'll see that in a minute. And because an unrepresented plaintiff, such as EON, is not permitted to proceed as a relator on behalf of the government in a QI-TAM action. The False Claim Act, 31 U.S. through 37, this is actually from the Act. QI-TAM under False Claims Act allows persons and entities with evidence of fraud against the federal programs and or contracts to sue the wrongdoer on behalf of the United States government. See, it allows individuals. Okay, hold on. The QI-TAM action, the government has the right to intervene and join the action. If the government declines, the private plaintiff, singular, may proceed on his, singular, or her, singular, on. Wait, hold on. Some states have passed similar laws concerning fraud in state government contracts. Okay, so the judge says that a private individual, such as EON, is not permitted to proceed as a relator on behalf of the government in a QI-TAM action. Not a private individual. Served the Attorney General. They didn't respond. Remember we said we were waiting for them to respond? They never responded. Gave them more than 30 days. This is supposed to be a little too. It says in December 12, 2017, the plaintiff filed the present motion for reconsideration with this court's October 26th opinion, which was marked fully submitted on January 24th. Submitted. Ain't nobody submitting nothing to you. Well, anyway, January 24, 2018. Now, he mentions that the court came to their decision on October 26. We didn't receive that decision of the court until December. You guys saw the video. He says they reached their decision on October 26, and it's a unique thing that our mail is logged in with the post office. But they do that all the time. They've been doing that a lot. They've been delaying. When we've been asking for it to be mailed, they've been delaying the mailing. But they're claiming they sent it on October 26th. This is the third case, ladies and gentlemen, that we have where the court is saying that they mailed things out, but we actually have the actual label on the envelope and the actual receipt through the post office. That's why we have things sent through post offices, so that if they claim they sent something, we can prove that it was not received until such and such time. Anyway, Section 3730B2 provides that in relevant part that a copy of the complaint and written disclosures substantially of all the material evidence and information the person possesses shall be served on the government pursuant to Rule 4. Ladies and gentlemen, the lawsuit contained all of that in the actual lawsuit. It even referenced the Attorney General's lawsuit and all the evidence they collected, because I told you they were our investigators. We don't have to hire investigators and researchers and all of that stuff. They already did it. The federal rules of civil procedure. The complaint shall be filed in camera, in private, and shall remain under seal for at least 60 days, and shall not be served on any of the defendants until the court so orders. We did that, ladies and gentlemen. But he's saying that it didn't happen. And it actually did. Now it says the United States Attorney General's Office for the Southern District of New York, representing the United States of America, although not a party to this action, submitted a statement of interest representing the true party in interest in this and all QI-TAM actions. He's saying that this is the office that should have been served. Well, guess what, ladies and gentlemen? That was the office that was served, the office in New York, not the office in D.C. We gave him that information. Okay, he ignored it. He says he didn't even receive our proof of service or the affidavit. So you'll see what my response was. The applicable standard under Local Rule 6.3, a party moving for reconsideration must demonstrate to the court that it overlooked the controlling decisions or factual matters which were put before it in the underlying matter. We did that. Told the court that you failed to take a look at this, you failed to document this, you failed to understand that. We told the court what it failed to do. The major grounds justifying reconsideration are an intervening change in the controlling law or the availability of new evidence. We gave them an affidavit. Or the need to correct a clear error or prevent a malfeasance of injustice. We told the court that it would be an injustice on its part to continue to act as if the Attorney General had not been notified and it did not have the right. So it says that's what the proof of service and the unrebutted affidavit were presented for. Okay, but again, this is just him saying that, look, they don't want this to go forward. We understand. It's okay. The standard for granting a motion is strict and should only be done when the movement can point to controlling decisions or data that the court overlooked, matters, or other words that might reasonably be expected to alter the conclusion reached by the court. Such motions are not vehicles for taking a second bite at the apple. In other words, it can't be used as an appeal. Internal quotation marks cited and omitted, and should not be granted where the moving party seeks solely to reiterate an issue already decided. Ladies and gentlemen, we definitely weren't trying to do that. But again, Judge Sweetie, knew what he was doing. The plaintiff's motion for reconsideration is denied. In his motion for reconsideration, the plaintiff contends that the court improperly characterized the law as holding that a pro se litigant is prohibited. See, he said we didn't explain all of that. Prohibited from bringing qua-time actions. The plaintiff also didn't argue. Well, you just said you were going to present your argument. Nope, didn't argue. I was just letting them know what the law says. Okay. The plaintiff also argues that the court maintained an incorrect understanding of the facts in finding that the plaintiff failed to serve the government pursuant to this. However, the plaintiff has provided the court with no new, pay attention, he says no new controlling law or relevant factual evidence, so the plaintiff's motion is denied. He's saying that the affidavit and the proof of service form, the original and signed proof of service form, plus an additional affidavit were not good enough. Okay, and he's saying a plaintiff may not bring a qua-time lawsuit because pro se litigants can only act on their own behalf and not for the benefit of others and are their interests. Ladies and gentlemen, I have power of attorneys. I'm not represent such as the government. Of course, I can represent the interests of the government. That's the whole purpose of bringing a qua-time lawsuit. Okay. Noting that the government is the real party of interest in a qua-time action. Moreover, qua-time actions must be dismissed with prejudice, and he goes through all of that, holding that the plaintiff's failure to abide by the statutory requirements for bringing a qua-time action warranted dismissal with prejudice. See, he's saying that it was a technicality. Okay, so now, without going into, because he's just repeating, he literally is repeating what he wrote in the first one. Let me give you guys what we wrote in this one. Okay, and we call this an administrative notice of appeal, administrative notification. Now, I'm going to reword it because I have to, but I'm letting you guys know what we did so far. So here you go.
By administrative notification. One objection and exception is taken to the court stance in claiming that it did not receive proof of service on the Attorney General and/or its representative. 2. Proof of service was included along with the filing of reconsideration, and it would make no possible sense on this planet for anyone to play this bureaucratic game with a judicial officer who claims someone brought forth an argument, when it is a known fact that the court is prohibited from listening to arguments and/or considering rationale. 3. The congressional intent of a qui-tam lawsuit was to acknowledge a private party's right to bring suit on behalf of the government as a whistleblower. According to the court and its so-called case law, a private party by statute does not have the right to bring forth such a suit. That is an absurdity. That is gatekeeping. 4. The other contention is that a process server did not serve the Attorney General of the Southern District of New York, despite the fact that there is an affidavit on record from the process server which this court has failed to rebut. An unrebutted affidavit stands as fact/truth in law. This court has failed to provide any information that will cause it to ignore the service of process on the Attorney General, and I do not accept the court's blockage of my access and or the individuals I represent access to the court. 5. This court seems to believe that the only action being brought before it was qui tam. It did not mention the other provisions the suit was being brought, and because we live in a country where everyone is represented in the fashion of the legal entity, under legal names, under personage, of course a private party can represent the interest of legal entities, as long as they have power of attorney. 2. Judicial officer knowing and intentional misrepresentations. 6. There is a deliberateness with the writings of this particular judicial officer. It is distressing, disheartening, and disconcerting that such a senior learned individual would claim that a court's opinion trumps congressional intent. 7. This court seems to be of the opinion that we are supposed to explain the law to the court, when we are under a so-called national emergency, the March 9, 1933 Act, when the court has stopped operating in its constitutional capacity but operates now in an administrative capacity. It failed to understand that we were bringing forth a constitutional claim, a constitutional challenge that the entities listed as defendants have acted in conspiracy to cause damage to United States of America citizens and the United States of America. 8. Retrying the case, during an appeal by way of reconsideration. A reconsideration motion is nothing more than a writ of error in generic form. The federal question on appeal is, since judges are learned individuals, admission and law, are they not required, expected to know the law? And if they are expected to know the law, when they ignore the law, are they not liable to the law and those whom they have caused harm to? 9. Is it an error on the part of the court when a judicial officer commits an intentional act to obstruct justice, that is ignoring the rights of citizens, and the law? 10. If a judicial officer knowingly, and intentionally, ignores the rule of law, in that the courts must go according to and in line with the dictates of the intentions of the legislature, does the fact that this particular court refused and/or failed to do so not constitute a void judgment? 11. These are the foundational principles by which the appeal will be brought before the Court of Appeals. The issue before the court was not whether or not it was the intentions of Congress to specify the fact that a private individual could bring forth a suit, but that a private individual could bring forth a qui tam lawsuit on behalf of the United States government, which has to go before the Attorney General, giving that party an opportunity to represent the United States government. 12. That in bringing forth a qui tam lawsuit, a party is doing so not pro se, but as a representative of the United States government, that is under the sovereign process, sovereign capacity, and not in an individual capacity. That a party coming in as a relator is not pro se, but at Attorney General, that is an attorney, be it private or otherwise, again under the intent of Congress, not pro se, not a private individual, but a private Attorney General. 13. Yet the court wants everyone to presume and assume that it has the authority to block access to a whistleblower, contrary to the intent of Congress. 14. The court had a signed affidavit notifying it that the Attorney General had been properly served by an individual over the age of 18, yet the court says that it had not received the affidavit and the proof of service, despite the fact that it was attached to the original pleadings to the court and the reconsideration presentment, which means the court is claiming that the clerk of the court is interfering with the access to justice, because they are responsible for the proper filing of documents. As by law, this court must recognize that it has provided proof that it has received the documents, in that it documents that it has received the motion for reconsideration, and the reconsideration motion refers to each of these points, does it not? 15. So this notice appeal is hereby being presented as judicial and administrative notification, and we must ask that when this matter is remanded back to this court, that the judicial officer recuse himself due to the office prejudice and his misinterpretation and understanding of statute. The aforementioned is accurate on this March 26, 2018, so help me God. EEON, Relator.
Okay, ladies and gentlemen, I apologize for that. I don't have to do a lot of cleanup of this document because it's just a notice of appeal, but it actually stipulates and states the points necessary. And you know what I think I am going to do? I think I am going to petition the court for a stay pending the appeal, because I have to do that. So I have to do a separate other motion for a stay pending appeal. It's just something I have to do because I'm going to be asking for a stay in the appeals court. Now, they're going to deny it, but I have to do it as a matter of course. By the way, also, we're telling all of you guys about federal question. Well, the federal question is going to be simply this. I just had somebody call me about the federal question, and so it had me, my mind is on 100 different things at one time, as you can tell even by the way I'm talking right now. So the federal question, and I come in as a non-taxpayer and American citizen. Has the Constitution been suspended? That is one of the federal questions. In 1789, the United States of America Constitution was enacted by the people of the United States of America and a joint session of Congress. The question is, since it was enacted, we're going to ask a question within a question. Was there a statute of limitations on that instrument? Second, could that instrument ever be suspended? Now, the reason why they're saying it could be suspended is because the Constitution made writ of habeas, or the right to habeas corpus may only be suspended during times of war. Okay, it's because of that they're saying the Constitution can be suspended. However, this is what you all need to pay attention to. Because we have a declaration in 1933, Congress is saying because the president declared a national emergency, we're not in a state of war. Well, technically we have all these wars, but if the Constitution was suspended, we're asking that question, does the act of March 9th, 1933 give Congress the right to do what it does? I have to pose the question the way it goes with the Constitution being suspended, because I need them to say on the record that the Constitution has been suspended. Not if the Constitution has been suspended, but I have to get them to say on the record the Constitution has been suspended. So that's what I'm working on. Like I said, it'll be at least 2 weeks. I thought by next week, but sorry, something else came up next week, so I don't have next week. So it will be at least 2 to 3 weeks before I can even get around to finalizing this and putting it out there for you guys to add to what you want to add to. With that being said, ladies and gentlemen, I was going to let y'all go. I just wanted to bring this to you, the Defrauded Homeowners of America lawsuit individuals. Oh, and by the way, I can't give you guys all the strategy. They watch my videos. So I can't even send it to you all in the email because some of the people who have signed on to it is the actual government. So I can't give you guys the strategy, but please understand there will be another lawsuit under different items, different points that will be filed shortly within the next month. So I just need you to hold on, be patient. That's why we haven't had anybody else signing up, because we want those of you who did sign up in time to be the ones who benefit the most from the suit. Okay? And as I promised you, gave you my word, we're working it out to where we can give you back your funds in credits, plus keep you still part of the lawsuit. But you're going to have to be patient with us. We're working that out now. Ladies and gentlemen, gentlemen and ladies, ladies and gents, with that being said, let you get back to your days, your lives. Have a good day. Have a good night. And I don't want you to worry about the court dismissing it, because it will be remanded back. Like I said, there are certain things the court was supposed to do, and I will put that in the appeal. See, when he says pro se, a normal person would focus on the word pro se, that I was representing everybody pro se people. That's why I did a QTAM lawsuit. So I could not come in pro se, them saying that I couldn't represent all of the people. That's why it was a QTAM lawsuit and nothing other. That was already thought about in advance. So I'm already prepared for the arguments. This has not been a week in the making. This has been we're going on almost 7 years now planning this lawsuit. All right. Have a good day, everyone. We will talk soon.